And Logan Kegley, can you start your, Kegley, can you start your, all right, sir, you're set for bench trial. You're wanting a bench trial, is that correct?
A bench trial?
Yeah, so you're wanting a bench trial? We've got you as speeding 75 and a 65, which is a $45 fine. You were you wanting a bench trial or diversion, or what were you wanting to do?
Uh, well, certainly no diversion.
Okay, so you want to do a bench trial? Do you want to challenge it or admit it and pay the fine, or what do you want to do? I'm not trying to influence you. I just want to know what the rest of my docket looks like.
Okay, well, what if I was to pay the fine today, would that be, on a record at all? I'm basically trying to
Well,
avoid higher insurance costs.
is
It
that
does
is
look
that
like a
a,
moving violation. It's 10
it
over, so
does 10
yeah.
over, just barely a moving violation. Okay,
Just barely a moving violation.
just barely. 10 over and above is moving. Is it
Okay.
10 and above or 10
Yeah.
over 10? Okay, 10 and above. All right.
I do believe. Let me double check.
Okay.
After this morning's docket, I feel like I don't know up from down, quite honestly.
Yeah, it's been different. Let's hope it doesn't become the norm. It's just this docket usually is a little smoother. Missy and I were talking about that.
Actually, no. It looks like just based upon a quick search, 10 miles per hour or less over 55 plus mile per hour zones is not a moving violation.
Okay, but he's not 55, he's at 65. Is that
Right.
what
Well,
kicks in?
it's
Okay.
speed limits of 55 or greater. So
Oh,
55, 65, 70, whatever it is, if you're within 10, it's not considered a moving violation.
so he's got a non-moving
Usually
violation.
not a moving violation is what the research is telling me.
I know the 10 over is a magic number, but I couldn't remember if it was over 10 that it kicked in or if it
Any
was at 10.
conviction, posted speed limit at 55 miles per hour or more, but not exceeding 75 miles per hour by not more than 10 miles per hour. So pursuant to KSA 81560C, small c, no parenthetical, subsection B, this is 10 miles per hour, not more than 10 miles per hour. Okay.
So it sounds like it wouldn't be on a record then, correct?
That's the way I'm reading it. It says not exceeding 75 miles per hour, and that's you were cited at 75 miles per hour. So my strict reading of it would be no moving violation. But I'm not your attorney either, but that's the section if you want to go look it up on your phone. And decide how you want to proceed. We do have our officer here. We're ready to proceed to trial if you want to do a trial.
It's strictly your choice, Mr. Kegley. You have no wrong answer. If you want a trial, like you said, we're ready to give you a trial.
It doesn't bother me either way.
All right. Well, yeah, let's go ahead and pay a fine, and I'll pay a fine, and
Okay.
so.
And you said it was
Yeah.
45, Judge, so that is the basic speed fine. So
Right.
you're Mr. Kegley, it's an infraction.
$45
Meaning,
fine.
yeah, $45 fine, 108 court cost. How soon could you pay that?
I can pay that right now.
Okay. Your Honor, if you want to inquire, I'll start the journal entry.
All right. You understand, Mr. Kegley, that we are set for trial. Deputy Penland is ready to proceed. He's here on his subpoena. But do I understand that you're wanting to waive your right to trial and plead no contest or guilty to the charge?
You're understanding correctly, Your Honor.
All right. Is it a no contest plea you want to enter, or is it a guilty? No contest. Guilty means you admit it. No contest means you don't want to admit it, but you don't want to take it to trial either. You're basically standing legally mute, but I'll still find you guilty.
Okay. Well, yeah, I've never understood that whole no contest bit. Either
Means
way,
it's not sir, another way to look at it means it's not an admission that could be used against you in the future. It would be probably more significant if you were involved in a traffic accident.
That's
And there was a property property damage claim that you disputed the amount of the claim. Well, if you admit it, if you plead guilty to certain criminal offenses, those could be used as admissions against you in a civil case, saying that you damaged somebody else's property. Where if you plead no contest, you can still resolve the case, but that's not a legal admission that could be used against you in another proceeding. In a speeding offense, it probably has very little impact. But again, that's just my analysis. I can't represent you as an attorney in this case. So
right.
If you want to plead no contest, I'll be happy to just state to the court what the factual basis is.
Okay.
Or you can plead guilty if you feel free to admit it. It's however you want to proceed.
Okay. Well,
so if you want to maintain your not guilty plea and take it to trial, you're able to do so at this time. Do you understand that, sir?
I understand that. However, I don't feel comfortable representing myself in a trial.
Well, do you want time to hire an attorney? I can't appoint one, but do you want time to hire an attorney?
Well, to be honest, I'd like to resolve it now.
Okay. So you don't want time to hire an attorney. You want to proceed on your own behalf. Is that right?
That's correct.
All right. So how do you want to plead? Do you want to plead not guilty and go on to trial? Do you want to plead guilty, admitting the offense of speeding 75 and a 65 and proceed to sentencing? Or do you want to plead no contest, not admitting the charge, but not denying it and taking it to trial? You'd still be found guilty and proceed to sentencing.
Yeah, well, let's do no contest.
All right. So you don't want to admit it, but you don't want to deny it. Okay, go ahead, Mr. Dean.
Your Honor, the state would proffer that by the testimony of Deputy Andrew Finland, the Greenwood County Sheriff's Department, that on the 27th day of August 2025, at approximately 11:19 in the morning, that he was doing routine patrol in Greenwood County on US Highway 54 at approximately mile marker 298, which is within the boundaries of the corporate boundaries of Greenwood County, Kansas, that he did observe Logan Kegley operating a 2011 Toyota at 75 miles per hour in a posted 65 mile per hour speed zone. Again, all within the confines of Greenwood County, Kansas.
All right. And Mr.
And that
Kegley?
he did identify Mr. Kegley via a driver's license, which is noted on the citation.
All right. And Mr. Kegley, you understand Mr. Dean does not represent you. He's told you his interpretation of the statute, which sounds right, but he's not representing you today. Do you understand that?
I understand that he is not representing me today.
All right.
The prosecutor is not.
Okay. And you wish to proceed with your no contest plea?
I wish to proceed with my no contest plea.
All right. I find that you know what you're doing. You're doing it voluntarily in entering this plea. And I find that Mr. Dean has given a factual basis that if this were to go to trial, that's what the evidence would show. Therefore, I do find you guilty. Accepting your no contest plea, I give you the scheduled fine of $45 plus 108 court costs. Total due is $153. Do you need some time to pay that, sir? I can give you.
No, ma'am. I can pay it today.
Are you in Eureka today?
No, ma'am. I'm actually in Independence right now.
Okay. The reason I ask that is because you're not going to be able to pay online today. In fact, you're not going to be able to pay online until we get the journal entry on file. He has to prepare it. He has to get it to me. I have to approve it. I have to get it filed with the clerk. And so
if I showed up there, I could pay it then?
Pay it in person. You could pay it in person.
Okay. I'll head out now and head to Eureka.
Actually, this is just for speeding, right?
Correct.
Yes, so can
That's
you,
right.
And how much is it? 153?
153.
He can go
Total.
online and pay it because it's a speeding. It
Oh.
automatically
Yeah, that's right.
does that. So yeah, you can go online and pay it anytime.
okay, there you
Okay.
go, because they're scheduled fines and court costs, apparently you can do that,
And it's an infraction.
Okay.
So.
an infraction. Yeah.
Sir, this is just a drill. Officer, Deputy Penland, you're free to leave if you'd like at this time. This just got the case caption, state of Kansas versus yourself. This is the case number that's generated, showing the county, the year, and basically the number of traffic citation order. Showed that we're here on the 5th day of December, 2025, that you appeared via Zoom, pro se, meaning without an attorney, because it's an infraction, you're not eligible for an attorney. So court did not ask if you wanted to waive an attorney because court's not even obligated to give you an attorney. You entered a plea of no contest. Based upon factual basis given by myself, the court found you guilty of the sole count speeding, ordered that you pay court costs and ordered that you pay a fine. There's no jail possible unless you were in contempt of court. Fines $45, court costs are $108 for the total of $153 as mentioned earlier. There's nothing else marked on the journal entry except for my signature. Do you agree that that's what we did here today?
I agree. It's what we did here today.
All right. I'll get this to the judge and we get on fine, but as they said, you can go ahead and get it paid right now.
Right. And so I'll just use the court number or the case number, right, to pay it online.
Yes, do you have the online number?
I do not have the online number.
You have the clerk's number, you can call after lunch and get that number from them, or Missy, do you have the online number? Try that, sir, and if that doesn't work, please call the Greenwood County Clerk of the District Court and she'll give it to you. Her number is
Okay.
620-583-8153.
Okay, got it.
Looks like I just went online. Kansas Court Central Payment Center. I think if you just did a basic Google search of pay your speeding ticket online in Kansas, it'll take you to the page.
All right.
Okay. Okay,
Well,
I'll do a basic search for that. Thanks.
But if nothing else works, make sure you call the clerk. She can give you the official one. They have
Okay.
made that. Well, I don't even try to memorize it anymore. All right.
I've
Thank you
changed
all.
it around too much.
No,
Alrighty.
All right.
I'll get on there to do that. May I be dismissed?
you are dismissed at this time, Mr. Kegley. Yes,
All right.
thank
Good
you.
luck with
Yes,
everything,
take
sir.
care. Thank you.
You too.
Thank you. I appreciate it. Thank you.
Uh-huh.
Ready to come on. You called them. Try to get this one done. Court does call the case of the people versus Mohammed Day.
Ashley Feltus with the people.
And Assistant Public Defender Natalie Pate.
Big gun dog, nigga.
Mr. Deanne, please keep yourself quiet in courtroom.
This case go, you're
This is-
fired. Conflict of interest. I'm a blood too. Can I get the fuck out of here now?
Mr.
She's
Deanne,
fired. I would like to schedule for, get the
Mr.
fuck off
Deanne.
my case. You're fired. You're
Mr.
fired.
Deanne, please
I'm not
stop.
playing to shit. You're fired. With the ugly ass, dusty ass suit. I'll represent myself. We can schedule for trial. When's your trial docket, please?
Well,
Conflict of interest. She's ugly and she got a dirty ass suit on.
Hang on.
Get the fuck off my case. Where your wig at? Where is your wig at? Where is your fucking wig
Mr.
at?
Deanne,
Suck my dick. Let's go. Let's go, bitch. I'm out of here. Can you suck my dick right now? Don't be putting yourself and suck my dick or warrior dick.
Yes,
Mr.
Nah,
Deanne,
move. Treat time, high room.
Mr. Deanne,
Big red
Take
fuck,
him out.
get in the red, spread your booty cheek, so me and my nigga can put my dick in. That's why you got two cheeks, bitch. Fuck a bitch. Why you wonder why they call you bitch? I bet you. You got two booty cheeks, one for me and one for my nigga.
I apologize to the court.
What? Did you have anything to do with that?
No, but I still apologize to the
Yeah, but no, you don't, yeah.
Thank you
I,
for the to reauthorize this felony, as stated on the sheet.
yeah, so it's coming back to me.
Yes.
Thank you for the apology, Miss Pate, but you really didn't need to apologize. I knew what I was gonna be starting my date with. So This case, that case is, if in case anybody didn't hear, the misdemeanor is dismissed. In Arbor Woods versus Keir Morris. Keir Morris. This is her motion to set aside default.
It is indeed, and we did file.
I'm here, Judge. I'm sorry, I couldn't get my phone on to work.
All right, that's her. Oh, there you are. Hello, state your name.
Keir Morris.
All right. This is your request to set aside the default.
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing?
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed some to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arbor Woods paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Dornbush?
well,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you, you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My
Well,
rent was supposed to go
First
up
of all,
in August. I'm sorry.
there was, so, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, there was, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the
Yeah.
hearing on, I think, November
Correct.
17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms.
That's
Moore was
absolutely not true,
100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can pull up the ones that I have and I can send it back into the court.
Ma'am,
So
I have your signature
mhm.
on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing. And it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
I'm
and it did
confused
not
on the
get filed.
motion.
It
Go
did
ahead.
not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I do.
So,
I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff and we're trying to come to a resolve. So my information hasn't changed. And my issue hasn't changed either. And if we would have been in court in May, because that ledger says I had a balance.
ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct, the same
So-
day, Judge. Ms. Dornbush is not
But-
acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of
Do
2025.
you see that on the account, Ms. Thornbush?
I do see that, Your Honor, and I believe, but I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try
Right.
to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June. Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well,
I mean,
sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand that
what is
they
her
didn't.
current balance?
the current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in
I know
September.
that.
Okay,
So
I'm saying in
you tell
September.
me,
Yeah.
taking out all of
Mhm.
that,
Mhm.
how much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was owed was $360
Did you pay
and 6 cents.
December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as
Okay,
well.
I've got 700. So you're saying that if I take that 700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your
You
Honor.
can say absolutely not
Where
if you
is
look at
that
the
gonna
first.
come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right, so in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so
that's
even if they did
$85 per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is $55 that gets charged on after the 5th and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Ms. Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, Listen
If
to
you
me.
look on, if you look on my
Listen
ledger,
to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm
yes,
asking
sir.
you for where that discrepancy is.
Okay,
You
sir,
have
and
given me
I'm,
150. I'm not
sir.
agreeing with you. I'm just saying,
Mhm.
where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I go into the office, they say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out she sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You
Okay,
have
so let me
given
rephrase
me
this,
a
Judge.
total amount
Mhm.
of $490, basically, that you're
Mhm.
saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually input it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow. In November, my rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was
All right,
supposed to start in August.
ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can
It's the
send it back
motion
in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how
And
does it not make sense from me, but it makes sense from the attorney? You're being
done.
biased.
I'm done. You're not
You're
going to
biased.
interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're
Motion
very
denied,
biased.
writ may issue. Thank
You're
you.
very
I'm done.
biased and disrespectful.
I'm done.
It doesn't matter. You're
I
disrespectful and
am
you're very
done.
biased. You need to do your job.
I
You don't know
am
how to do your
done.
job. That's
Mute
all.
her. I am done. Motion denied.
Your Honor, I would request that the money's held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney, you have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her out of the meeting.
Now, this one is Mr. Adrian Jacob. He's ready to go. It's an MTRP, and he's pleading true.
And two cases are now called. Cause numbers 23 CR 1411 and 23 CR 1838. Motions to revoke unadjudicated probation in the cases of the state of Texas versus Adrian Jacob. You were Mr. Jacob.
Yes, sir.
Present with Mr. Adams, you were attorney and the state's attorney. Does the defendant waive formal readings of these motions of to revoke unadjudicated probation in 1411 and motion to revoke probation, which I guess was regular probation, in 1838? Can we proceed in summary?
Yes, sir.
Okay, I don't see any agreements.
He's gonna plead true and he's gonna go to you, but I think the state is gonna make a recommendation.
All right.
The state is gonna make a recommendation.
And in summary, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you guys. Lower your hand. In summary, 1411 states that on March 31st, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of aggravated assault with a deadly weapon. Is all of that true and correct, sir? Allegation 1 states you committed the offense of theft on or about April 6th, 2025, which would have been a week after you were placed on probation?
Right.
In violation of your probation order here in Jefferson County, Texas. Is that true or untrue?
Yes, sir. He says true.
2, you failed to report to the Jefferson County Probation Office since being on probation on March 31st of 2025. Were you arrested earlier on this, or was there a period of time that he did not report until he gets arrested? How long? You were supposed to report monthly.
Yes,
Yes.
And did you fail to do that?
Yes, sir.
When did you finally get arrested?
Um,
Do you remember?
I don't remember the name.
I would. It would be
It was,
important to me.
I got arrested on the 3rd, October 3rd.
October. Okay. So you were supposed to report, you were placed on probation on March. So you would have had to report April, May, June, July, August, September, and then in October you get. So what's that? 7 months go by that you didn't report. Is that true? About? It's 6 or 7 months.
Yes, sir. Yes, sir.
Oh,
Yes, sir.
so is that allegation true and correct?
Yes, sir.
I'm going to stop at that. Okay. Are you pleading true to allegations 1 and 2
Yes, sir.
of this motion to revoke probation voluntarily, knowingly, intelligently, and because those are true as they are alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced no less than 2, no more than 20 years confinement in prison, since this is a second-degree felony. Knowing, understanding, and appreciating all of that, do you insist on pleading true today to these violations?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true
Yes, sir.
to violations of probation.
Yes, sir.
Let's hold that in abeyance. Okay, go to 23 CR 1838. Again, does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
And again, you're under oath, sir. In summary, this motion filed on September 29th, 2025, as well as the previous motion, it states in this other case that on March 31st, 2025, the same day you were placed on probation in the aggravated assault with a deadly weapon, second-degree felony case, that you were sentenced to 2 years in this court in the state jail, probated for 5 years for burglary of a building. Is that true?
Yes, sir.
And allegations 1 and 2 are the same. That number 1, as before, the previous case, you committed the offense of theft on or about April 6, 2025 in Jefferson County, Texas, in violation of your probation condition 1 and 2. You failed to report to the Jefferson County Probation Office in violation of condition 4 of your probation supervision order by absconding in April and not being arrested until several months later. Or allegations 1 and 2 true as well as they were in this previous motion to revoke probation?
Yes.
Are you pleading true to allegations 1 and 2 as well in this case?
Yes, sir.
Are you doing that voluntarily, knowingly, intelligently, and because this is true,
Yes,
as
sir.
it is alleged? And again, do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation could be revoked in this case, and you could be just sentenced to no less than 180 days up to 2 years in the state jail.
Yes, sir.
Knowing that, do you insist on pleading true as well today?
Yes, sir.
I find you are pleading true voluntarily. In each of these cases, you understand and appreciate the consequences of pleading true and how that might make you vulnerable to revocations of these probation orders in each case. There is no agreement in each case?
Well, we come to you.
All right, go ahead.
Judge, I know that you just pointed out specifically the time.
Report? I'm going to look at the pre-sentence report while you're talking, okay?
I noticed you pointed out the time frame from the point that he got on probation to the point of this violation. But I think we're asking the court to take into consideration why it happened so fast. He was homeless, and talking to him, the object stolen, it's not like he was stealing a car or going stealing something major. To my understanding, it was buckets of water, not buckets, but bottles, cases of water. And the reason that he was getting that water that he was stealing, Judge, is that he was destitute and homeless at the time. Yeah. At the time, he was destitute and homeless. And Judge, we're asking you to have mercy on him because, like I said, this is not a situation where you got a guy going into dealers and let's say he's stealing a bottle of cologne and resell it. And I totally get that. But this is a situation where he was destitute, he was homeless, and it was for his needs, his bodily needs, which would be water and cases of water. And Judge, I spoke with the prosecutor on this case as well. What I'm asking is that if you just give him one more shot, leave him on probation. I do believe to get him out of the hole that he's in terms of his economics, he will be able to get a job, right? I have somewhere to stay there. And he has a place to stay. And I believe some of his family members are gonna step up this time for him. Yes. So just looking at the nature, and he's accepted responsibility on the theft case. Yes, sir. On that theft case, Judge, if I'm not mistaken, and you can look at your file, I believe the misdemeanor court put him on probation for that theft. So in the misdemeanor court, they gave him probation. And who was your judge on that? That was Holmes. Mm-hmm. Yeah. Okay, I believe it was Judge Holmes. Yes, yes, so, Judge, what we're asking for is for you to continue him on supervision, move the case today, and consider his economic situation at the time. And that's why it happened so fast. And also consider the object that was stolen was not an object of, personal gratification. That's what he's telling me. Yes. At least that's what he told me. Okay. So that's what he told me.
But he was placed on probation for
That's what you said you told me. Cases of law. That's what you said.
In 1411, that the defendant um, broke into the victim's truck, and that then he was armed with a knife and cut the man, is what he's alleged in this aggravated assault with a deadly weapon.
Yes, sir.
And
The other one was the MTLP for burglary of building.
um, he was later arrested and for the stabbing incident and indicted and placed on probation for that aggravated assault of March 31st of 2025. In September, they released go again to Crystal Apartments on Gulfway Drive. Oh, 2 blocks away from the previous incident. And on September 5th and 23. And go to a theft that's reported where the victim reports that he stores industrial and commercial paint sprayers in a storage building, and surveillance video was acquired by the police who show the defendant and another person stealing those items as they are in a Chevrolet sedan with no license plates on the front or rear of the car. They back into a spot. He and another person get out, steal the sprayers, then take off. And then Mr. Jacobs apparently is known by the Port Arthur Police Department, and he was recognized. And that apparently that there were 2 thefts of the sprayers on the same day at that same location. And police find the defendant, Mr. Jacobs, and he admits being involved with it. And so he's placed on probation in these 2 cases of aggravated assault and burglary of a building. He's placed on probation and given another chance in spite of the fact that he has how many prior felony convictions of burglaries and forgeries? How many? So, because there's so many, I want to know if you can recall how many you have been convicted of.
I can't say.
You can't even remember. What does that say? I know of 7 burglaries of homes and back to 91. A burglary of a habitation, somebody's home. 3 years later, you're convicted of another burglary of a habitation. You get 15 years in prison. Then in 94, you're also sentenced burglary of a building, 15 years, because I guess it was enhanced because of the prior conviction. In 2000, another burglary of a building, 3 years in prison. Forgery in 07, a year in jail. Burglary of a building in 09, convicted, 6 years in prison. Then in 23, you were convicted of burglary of a building in January of 23. So those are the felonies. And let's not forget, I'm looking at a page full of misdemeanors, which are deep driving while license suspended, driving while intoxicated, theft, burglary of a building, of a vehicle, burglary of a vehicle. Anyway, so those are 4 convictions of misdemeanors, 7 convictions of felonies. And then now we have these 2 revocations. We're back. And it's as though everybody is spinning our wheels. I mean, you're not only continuing to commit a crime, but and you're not reporting. And hold on, let me just this, you keep talking about water, but the administrative hearing doesn't say that, Langston. It says that on April 6th of 2025, the date that this theft occurred, allegation 1 that he is admitted to, it states he committed theft on or about 4/6/25, stealing someone's wallet containing about $1,000 in cash, a debit card, and insurance cards at a local HEB grocery in Port Arthur.
And what did he? He said, right, and Judge, I talked to him directly. He's saying that he had nothing to do with that. He's telling me that, didn't you tell me it was water?
Yes, sir.
I heard him correctly, Judge. He told me that it was water, and he was stealing because he was destitute and he needed bottles of water to drink. Is that what you told us? Judge, that's what he told me.
That's what the administrative hearing states is what this is. Okay. So now I've got a police report to look at your Sunday. On April 6th. There's on arrival on 4/6 at 21 at 9 p.m. Officers respond to Gulfway Drive at the HEB. Made contact with a manager who advised me one of the customers had her wallet stolen. I watched the video footage from the store, and then the video shows a male black approaching the victim near the produce area. She had her wallet on top of her cart. The suspect is observed walking toward her shopping cart as she's getting some produce. Facing away from the shopping cart, the suspect reaches for the wallet, which is on top of the shopping cart, and continues to, and then conceals it in the pocket of his sweatshirt. The suspect left the store shortly after, got in a passenger front seat of a dark green Chevy Trailblazer with no front license plate. The victim I was advised the victim had $1,000 in cash or debit card, as well as an insurance card for her children. She did wish to press charges. I spoke with the manager. Manager advised that the video had already been tagged, and then that's all it says on that. On April 8th, 2 days later, Detective Thomason with Port Arthur PD receives the case for follow-up investigation about the HEB theft. Let's see, the surveillance was played, captures the suspect taking the wallet, provided me Ramirez provided me a video and printout of the transaction. The name, let's see, the surveillance was played back. It captured the suspect taking the wallet. The suspect is a light complected African American with short hair. The same male bought items and used a card. Investigator Ramirez provided me the video and a printout of the transaction with the male suspect. The name on the transaction is Adrian Jacob. I am very familiar with Jacob. I've known him for many years through my employment as a police officer at the city. I personally filed many cases against him. I reviewed the video. There is no doubt the suspect is Jacob, not only by his face, but he has a distinctive limp and is noticeably bow-legged. All right.
So you told me that it was water, right? Yes, sir. So I guess the question the judge is raising is that based upon what he read, was that you?
Are you pleading true to these or not?
Yes, sir. Yes, sir. He pleading true. He said he pleading true to still.
All right. Well, then you can't say I'm guilty, but I didn't do it.
Yes. So you're saying that you're
Yes,
guilty?
sir.
He's saying he's guilty. Judge, I'm not misremembering. He told me it was water. That's what he told me.
That's what you can see. It's not a necessity of life here. This
I'm just saying what he told me.
I know. I know what you're saying, but we're going to clear the record up.
Yeah.
It's somebody's wallet and ID was used, and that was used to forge and commit theft. That's on that case, and then we have the burglary of a building matter. But so the defendant has pleaded true in each of these cases and admitted culpability. So the question is, what do we do in the aggravated assault? He is looking at no less than 2 nor more than 20 years confinement in prison. I think there was a loss of $700, wasn't it?
Your Honor, in the burglary of a building, it was actually $7,000.
Was $7,000?
Yes, Your Honor.
But in this one, the wallet contained approximately $1,000 in cash.
Yes, sir. And he's currently, I believe, on probation and misdemeanor court for that offense.
How does he pay it back if he goes to prison for 20 years?
And Your Honor, our recommendation, and we normally wouldn't do this, but he did cooperate and testified recently in a case for the state involving a serious offense, would be to revoke him on the aggravated assault, keep him on a straight probation.
How can I do that?
Well, it'd be then to keep him on the deferred there for the ag assault and sanction him to the max. But
so you wanted to sanction him? What would be the sanction?
The 180 days.
I mean, I'll take all of that into account, but no, I'm not. With his splendid and rich criminal history and continued, I mean, we're talking about aggravated assault with a deadly weapon here, where cutting somebody with a knife but okay, we've got this second-degree felony and then this state jail felony. What are you saying?
Well, Judge, and piggybacking on what the state just said, one thing we're asking you to give him credit for is that he apparently did testify.
And he's going to be rewarded.
for cooperation.
You'll be rewarded and with what I have in mind, but I want to hear what your thoughts are.
You know, I would want us to continue on probation to give him a second
Okay.
shot. But
It's hard on something like this when we're talking about a aggravated nature and then the burglary of a building. But he knows that actions have consequences, and the court is going to treat him with and give him credit for the cooperation he made. The problem you have, though, is that you can cooperate all day long. And did he testify in a trial?
Yes, Your Honor.
See, the problem is that when all of these prior convictions come out, the jury can't show a lot of credibility to someone because all of that comes out. And the law states that the jury can consider prior convictions against the credibility of someone so that their statements have less value of believability than they would otherwise by somebody who's doesn't have convictions of felonies. And so you may have helped, but I can guarantee you, I know how juries are. If all of these felonies came out, and maybe they didn't, maybe the other side didn't bring them out. And if they didn't, then they don't know about it. But I know it. And it would only make sense that the defense attorney would at least challenge his criminal history in front of the jury and then argue that he's not worth credible belief because the law says that can be taken into account.
I apologize, but actually can't give me another chance.
Sir, you've had 7 or 8 separate chances here. We talked about how many prior felonies, 7, and then misdemeanors, and then here we're still committing crimes. All right, anything else to add?
No.
And the court is going to take into account your cooperation. I'm going to find that there is sufficient evidence supporting each of these motions to revoke probation in cause numbers 1411 and 1831 to grant the motions by a preponderance of the evidence or greater, as the defendant has pleaded true voluntarily, knowingly, intelligently to the offenses alleged or the allegations of violations. Number 1 in each case, committing the offense of theft on or about April 6, 2025, and we cleared up what that was about. It wasn't water. It was committing the theft of somebody's wallet and money of $1,000 and ID. And then allegation number 2, failing to report, as the defendant was placed on probation and never reported, and for probation as ordered. And thus, those are violations that he has admitted to. They're proven by preponderance of the evidence or greater. And these motions, the motion to revoke unadjudicated probation in 23 CR 1411 is hereby granted. And the motion to revoke probation in 23 CR 1838 is also hereby granted. So your probations are revoked in each case. In this first case, 1411, where you were placed on 10 years deferred or unadjudicated probation, earlier in that case, you pleaded guilty to that second-degree felony voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, even though that case was that final finding of conviction and sentencing of confinement up to 20 years was deferred. That deferred probation has been hereby revoked by this court based upon these violations of probation. You were hereby found guilty beyond a reasonable doubt of that underlying offense, and you were sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. and you will be given credit for all time you've served. And there's an affirmative finding that a deadly weapon, namely a knife, was used in that offense. In 23 CR 1838, your probation has hereby been revoked in that state jail felony of burglary of a building where you were sentenced to 2 years in the state jail. That was probated for 5 years. Your probation in this burglary of a building case in 1838 is revoked, and you were hereby sentenced to confinement in the state jail for 180 days. These two sentences shall run concurrently. You understand what has happened today?
Yes,
You've
sir.
been given the minimum sentences because of your assistance to law enforcement.
Yes.
The order also shall reflect in cause number 1838, the 180-day sentence, restitution is ordered and the judgment in the amount of $7,000. That's what was ordered in the first place. Restitution will continue. We're going to take care of victims, and that will be part of the judgment. Do you understand what has happened today, sir?
Yes, sir.
You did get reimbursed for your cooperation.
Yes, sir.
That the state claims was helpful.
Yes, sir.
But still, you have to atone for the wrongful actions that you made. And I fashioned a method that shows award. But please learn from all of these. These are now 2 more convictions. That means 9 felonies. That's far too much, sir. Your legacy in life should be doing good things, not being an habitual felon. Please do better. Langston, anything else you want to add?
Nothing from the state.
And we are in recess. Thank you. Appropriation. All right. What's next? License.
State of Kansas versus Christopher Gene Wiedel. It's case number 2025 CR 324, and Bernoris appears for the state. James Watts is defense counsel. Christopher Wiedel appears on his own Zoom. This matter comes before the court at this time for pretrial conference. What announcement is made at this time, Mr. Watts?
Your Honor, after discussions with the state with my client, it is my understanding my client would plead guilty to count 1 of the information, the sole count. The state at time of sentence would recommend the low end of the box and follow the presumption. It may be that he will fall presumptive prison due to a special rule. The state would stand silent on a departure. Would that be the case?
Ms. Norris, has Mr. Watts announced consistently with your understanding as to how this Wiedel case would be handled?
Yes, Your Honor.
All right. Importantly, Mr. Wiedel, you've been present when Mr. Watts made an announcement on your behalf that you would now enter a guilty plea and accept conviction for count 1 in this case, theft after previous conviction, a level 9 felony. Is that indeed your intention today?
Yes, sir.
All right. I've got a whole series of questions I need to ask you regarding the taking of a felony plea. If there's anything that you do not fully understand, I will give you the opportunity to confer privately with your lawyer at any point. Just let the court know if you need that time to get further private advice, okay?
Thank you.
All right. State your full legal name for the record.
Christopher Gene Wiedel.
And how old are you right now?
48.
What's the highest level of formal education that you've attained?
11th grade. I got my GED.
Okay. Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, sir.
Have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health medications that you are not currently taking?
No, sir.
Mr. Wiedel, as you participate this morning, can you represent to the court that your mind is clear and that you have a full understanding of what's going on in court?
Yes, Your Honor.
Do you understand the nature of the charge in count 1, theft after previous conviction?
Yes, sir.
You understand that when you enter a plea of guilty, you admit that act that's been charged by the state?
Yes, sir.
Do you further understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge?
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial and present your evidence on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes,
You
sir.
understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
Yes, Your Honor.
You are also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
Wiedel, do you understand that you have a right to appeal a guilty verdict if you have a trial?
Yes, Your Honor.
Do you further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes, Your Honor.
Now, are you aware of the sentence that could be imposed as a result of this guilty plea that you're attempting to make?
Yes, sir.
Let's go over that. You would be on the non-drug offense grid at severity level 9 for the count 1 offense. In the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. However, in the worst criminal history category of A, you could receive up to a 17-month prison sentence. So the sentencing range is 5 to 17 months in prison, depending on your criminal history. We do not know with certainty today, Mr. Wiedel, what your criminal history is. That will be researched by the Court Services Department, and based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 9 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
If you're in criminal history category C or better, you would be presumptive probation in this case. But if at time of sentencing, you have 2-person felonies on your record at that time, you would be presumptive prison here. Do you understand that?
Yes, sir.
There's even been a suggestion here that you very well might fall into one of those presumption prison categories, and you're entering this plea with that possibility. Is that correct?
I'm not in that box. But yeah, I understand.
Okay. You also understand that you could receive up to a $100,000 fine for this offense?
Yes, sir.
Okay. In addition to any fine that could be imposed, are you aware that you could be assessed court costs, certain fees, including reimbursement of legal fees and expenses, and restitution
Yes,
of victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
Are you also aware that as a direct consequence of this plea, you will be sentenced to in an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yes, sir.
Both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances. Do you understand that, Mr. Wiedel?
Yes, sir.
The Kansas Sentencing Guidelines Act, Mr. Wiedel, is much more than the grid that I referred to earlier. It's an entire book of sentencing rules and laws. Among those are special sentencing rules. Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes, sir.
Did you have an ample opportunity to discuss legal matters like that with your attorney, Mr. Watts, before proceeding here today?
Yes, sir.
Okay. I think there may have been some mention earlier regarding departure. Do you understand the concept of departure?
Yes, sir.
Departure is a special exception to the general rules on sentencing, which are established by the legislature. A departure would have to be based on substantial and compelling reasons, and it's a discretionary matter with the court. So certainly, you should understand that you're not guaranteed a departure should one be necessary to have you on probation in the case. You understand that?
Yes, sir.
Okay. Now, are you satisfied with the services and advice given to you by Mr. Watts?
Yes, sir.
Is there anything else that you thought was part of this plea agreement that hasn't been accurately discussed on the record already, Mr. Wiedel?
No, Your Honor.
Okay. You understand that if there are any plea deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you, how do you formally plead to the charge in count 1, theft after prior conviction?
Guilty, Your Honor.
Okay. Let's go over what happened. According to the state's charging document in this case, Mr. Wiedel, this took place on or about April 23 of 2025. Is that when it happened?
Yes, sir.
And it happened somewhere in Butler County, Kansas. Where was it?
Is at the jail. I got out on a driving on suspended or whatever, and I seen it laying there. I thought it was somebody just left it or forgot it there. So I took it hoping that somebody would call it so I can return it to the owner. I didn't know that there was COs up there. I mean, it was wrong of me, yeah, but like I said, I kept it in the hope regard to get it back to the owner.
Okay.
So,
Mr. Wiedel, you understand that what you're pleading to presupposes that you took it with the idea of stealing it for yourself. You understand that?
yes, sir. I
And
had
if you're
my own
pleading
cell
guilty,
phone.
you're
Yes,
saying,
yes, Your Honor.
I stole the phone. Are you admitting to me that you stole the phone?
Yes, Your Honor.
With the intent to permanently deprive the owner of the benefit of that property?
Well, I was hoping to get it back to him, but yes, Your Honor.
Okay, just understand what you're telling me is a little bit inconsistent with the guilty plea to stealing the phone. You understand that, Mr. Wiedel? That's
Yeah.
why I'm asking you
Yes, sir.
that you are admitting that you took it with the idea of taking it away from the owner and making it yours.
Yes, Your Honor.
Okay. All right. Have you been convicted of theft-related crimes before?
Yes, Your Honor.
According to the state's charging document, you had 2 Wichita municipal convictions. So this would essentially be your 3rd conviction of a theft charge. Would you agree?
Yes, sir.
Okay. Would you also agree that the value of the phone that you took had a value of at least $50?
Yes, sir.
Judge, oh, sorry, we just lost Watts. He's coming back in.
I think I'm back, Your Honor. It went widgety on me.
All right, where did I lose you, Mr. Watts?
You had a conversation with Mr. Wiedel about understanding what he was pleading to, and the nature of what he was pleading to was permanently deprived.
Yes. For purposes of the record, Mr. Watts, the court is satisfied that he understands that he's pleading to that taking a phone that had a value of at least $50, and that he did it with the intent of permanently depriving the owner of the benefit of the property.
Yes, sir.
We'll go forward from here. So, Mr. Wiedel, do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for the felony crime of theft after prior conviction, a level 9 non-person felony?
Yes, Your Honor.
Okay. Mr. Norris, do you know of any legal reason why the court shouldn't accept this defendant's plea?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
All right, Mr. Wiedel, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea here today?
No, Your Honor.
Court will accept the guilty plea made by defendant Christopher Gene Wiedel and finds that that plea is made voluntarily. He has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the plea does exist. The court finds him guilty and adjudges him therefore convicted of theft after prior conviction, a severity level 9 non-person felony. The court orders a pre-sentence report be completed to accurately determine Mr. Wiedel's criminal history, and the court will set an appropriate date for sentencing. All right, Mr. Wiedel, I have to set that out about 2 months.
Okay, thank you, Your Honor.
You may be asked to do one or more assessments for the pre-sentence report. Most likely a risk needs assessment, possibly a substance abuse assessment. You need to contact court services promptly and make sure that you know what assessments need to be scheduled and completed prior to sentencing, because chances are I'm going to hold you accountable if these assessments don't get scheduled and completed. So the sooner you get
Okay.
on those, the better. We'll set sentencing out about 2 months.
Okay.
Meantime, you're going to remain on bond, Mr. Wiedel. You were the only participant who showed up on time, so you're obviously a good risk to come back for your sentencing. But I will need you at the Butler County Judicial Center in El Dorado, Kansas for your sentencing date. And you are local here in Butler County, are you not?
I'm in Wichita, Your Honor.
Okay, well, that's not too far away. But again, you are required to appear at the Butler County Judicial Center in El Dorado, Kansas for the sentencing proceeding that we're going to schedule.
Okay.
I may have tried to suggest this date to you before, Mr. Watts, and you rejected it, but I'm going to suggest it again. Monday, February 2. Which my calendar says is Groundhog Day.
Judge, I can do Monday, February 2. I don't see anything block it there.
Okay, perhaps it was another lawyer that had a conflict on that date. I don't know, Ms. Norris, are you involved in misdemeanor control docket?
Sometimes, Your Honor, but I can usually get away if you wanted to do something at like 9:30 or thereafter.
Okay, I'm looking at an 11 o'clock setting for Wiedel.
That should be fine.
All right. Mr. Wiedel, again, you'll need to be at the Butler County Judicial Center, El Dorado, Kansas for your sentencing, 11 o'clock, Monday, February 2. Court security will get you to the Zoom location where you will participate. 11 o'clock, Monday, February 2nd for sentencing in the case. Mr. Wiedel, to get off to a good start with the pre-sentence investigation, I need you to call court services as soon as we get done here. You have access to a phone today?
Okay. Yes, sir.
Write down this number. It's area code 316-322.
Okay.
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 We'll start over. 316-322-4153. That's the Butler County Court Services main number. Just let them know that you just pled to a theft felony and what do you need to do next for the pre-sentence investigation. And then that office will give you direction. Okay?
Okay. Thank you, Your Honor.
You've handled yourself well this morning, Mr. Wiedel. But I need to make sure that you take care of the pre-sentence investigation and be on time for court on February 2nd when we're going to complete sentencing in your case. Mr. Watts, is there anything further we need to address?
I don't believe so, Your Honor. Thank you.
Ms. Norris, is there anything further from the state's perspective we need to address here?
No, Your Honor. Thank you.
Mr. Wiedel, do you have any questions about what we've done here today?
No, sir.
If anything arises, Mr. Watts is a very experienced attorney. and he can answer any question that might arise.
All right, thank you, Your Honor.
All right. If there's nothing further, then the Christopher Gene Wiedel matter will currently be in recess, and this meeting may be ended for all at this time.
All right, have a good day, Your Honor. Thank you.
Good morning.
Good morning.
This is file number 242235ST. And 251420ST. You got 2 charges of disorder or driving suspended. Driving suspended is a very common, maybe most common offense. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driver's license and requires that your license be suspended. You got 2 of these. You got one in December of 2024. Then you missed several dates and they finally caught back up with you. And then you got another one in July of 2025. You have $1,129 of unpaid fines and costs. One of them is a previous driving suspended that was reduced to allowing another to violate the motor vehicle code. And then you've got several other plate and insurance cases that looks like they got defaulted. So $1,129. The plea offer sheet from the prosecutor, I think these are both under state statute, says the offer was to plead one and dismiss one. At this point, she's not willing to do that.
Your Honor, the offer was a plea to allowing another to violate the motor vehicle code. If she had had her license reinstated, she's working on getting her license reinstated. We're asking that this get set for last pretrial to allow her time to do that. If at the time of last pretrial.
One thing she could also do is pay her last fine for when she got a break like this. They reduced, allowing another to violate the motor vehicle code carries no points, and it doesn't get abstract to your driver's license. So it will allow you to try to get your license. So you haven't paid the fine from the last one, plus the insurance and registration stuff has to do with not having any money. So you get a driving suspended, then you don't show up for court, then you get another driving suspended, and you don't pay the fines. That's not a very good posture to be in when you come in for sentencing. Are you still at the Ash Road address?
Correct.
How'd you get here today?
My mom.
All right. Don't drive anymore to make it worse between now and then. All right. We'll have a bunch of final pretrials on a Thursday. You're good to go. Well, just before you do go, what are you actually doing to try to get your license back?
I had to request an administrative review of my driver's license to figure out why they even got suspended in the first place. So, and then I have to go to where the root cause of it is. And from my understanding, it's because of a automatic renewal for a registration that I didn't have any for a car that I didn't have no more. So I had to request.
Let's take a look. In the old days, they used to suspend you for unpaid tickets, like these no proof of insurance and no registration. They would suspend that for what's called FCJ, failing to comply with judgment. They don't do that like they used to, although frankly, I agree with it. If you get a ticket and you don't pay it, I don't mind the fact that you get suspended. But you were already suspended before that started.
Yeah, it was in 2020. It was, I was set up for an automatic payment plan for my registration, and COVID hit. They repossessed my car, so I no longer had the car. And in October, when they tried to push that payment through, there was no money in the account, and it came back as a bounce check.
You're on what I call the driving suspended merry-go-round, and it's very hard to get off of it. And this isn't in my queue, Matt. Luke. Let's see what I can tell you.
So have they scheduled it? I mean, is this imminent or is this something they're gonna do in July?
No, she told me they would get back with me within 7 to 14 days after they reviewed everything.
All right, when was that?
That was it was Tuesday when I talked to them.
All right. Well, this will probably not be until after the first of the year. Boy, there's a lot of stuff on here. 3-5. Let's see if I can give you any insight. Shows that you are suspended. You have these 2 unpaid no insurance tickets, one from March of 23 and one from July of 23. You have a driving without a license. According to this, you bounced a check.
That was the auto renewal online,
Okay.
correct? Yep. That's what
Actually,
started the sole suspension.
There's not that much baggage on here.
Right.
Just these. Now they aren't gonna say, okay, great, we're gonna give you your license back. And you've got all these unpaid tickets. So some of this involves money.
Okay.
You've got a number of unpaid tickets. They don't no longer suspend you for it, but they won't give it back either. So, plus you've got the one that's the misdemeanor, which you could go to jail for. I'm going to give you something that shows all the tickets that you have. Now, some of these, I think you got a ticket and then just didn't answer it. So those just get defaulted on a civil infraction. You didn't have a trial, you didn't get found guilty, you just didn't show up. And so that happened twice in the year of 23. So if you get another driving suspended, it's going to undo your ability to get your license for a while. But you really don't have that much bad stuff on here.
Okay.
Just some unpaid tickets and some other old stuff. All right. There's what your tickets are.
Thank you very much. And district clerk is right at the end of that.
All right. We've yet to do a plea today. One day earlier this fall, we did 28 pleas. I'm not even sure how we did it, but we'll probably have maybe 8. This is Cory David Miller. Good morning, Mr. Miller.
Good morning, sir.
All right, this is People versus Cory Miller, and again, we've met. Mr. Miller is charged with assault and battery and disorderly person. So let me pull this up.
And this is going to be a no contest. I do have the bond information report if the court needs it.
All right, well, let's find out. Mr. Miller lives up closer to Detroit.
Yes, sir.
He's been here for every hearing. All right, Mr. Miller has allegedly assaulted someone named Mason Booth way back in February of 2022. And he was also charged with being a disorderly person while being intoxicated out on Balk Road. This happened a long time ago. The warrant stayed open. They checked it a couple of times. Yet we sent him a notice to show cause. The Google search said he still lived at the same address, so he responded. We recalled the warrant and set the matter for pretrial today. So the prosecutor has reviewed it, and apparently prosecution and or the complainant wish to maintain that charge of assault and battery. Assault and battery, as I indicated, is punishable by up to 93 days in jail and a fine of up to $500. Prosecutor has offered that if defendant pleads to assault and battery by no contest, they will dismiss the charge of disturbing the peace, disorderly person. They're recommending time served, fine and cost, no probation, and no additional jail. Ms. Strong, is that your understanding?
That's my understanding. And my understanding is it's a sentencing agreement.
Okay, so if I don't follow the agreement, he would have a right to withdraw his plea.
Yes, Your Honor.
And I don't have an objection to that. I didn't discuss it with him, but this case is several years old. As I said, I had reviewed it several times over the years and renewed the warrant. This is a road rage situation. All right, Mr. Miller, do you understand that if you do plead to this charge, you'll be giving up all the rights that are on your advice of rights? And you sign that here. Yes. All right. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you allow or accept that a conviction would enter. Do you understand?
Yes, sir.
Anybody threaten you to get you to do this?
No.
Or promise you anything? All right, by pleading no contest, I'm going to get the factual basis from the bond information report, which your attorney referred to. We're going to dismiss the disturbing the peace or disorderly. True, the officers arrived at Balk Road and Sherman Mills Road for a report of a male subject, Cory David Miller, who was walking in the roadway yelling at cars. We were en route and advised the male subject had stopped a car in the roadway and reached inside the car and assaulted the driver. I made contact with Mason Booth, who stated he had passed Mr. Miller on the way to Dairy Queen. The girls have a song, "You Were Drunk and Mean at Dairy Queen." Booth told me he slowed down when Miller approached. Window was slightly lowered and he told Miller to get away from his vehicle. Grabbed him and tried to punch him in the eye. Should be noted that Miller at the time of the arrest was a .22, which sort of explains everything. Mr. Miller, how did you even happen to be out here in St. Joe County back in February of 2022?
I was dating a woman out here.
All right, how'd you end up drunk and mean at the Dairy Queen?
Your Honor, this is a no contest plea.
All right, I guess you're right. I'm just curious.
It was a very bad day for me.
All right, I guess we'll leave it at that. Your previous lawyer was our old friend, Melissa Halleck. Let's see how much jail time you got. You got arraigned. Then you failed to appear. And they issued this warrant for you a couple of times. All right. I'll try it. Thanks. All right, this happened on February 21st. Oh, that was through a bonding company. I don't have any money. You posted the bond the next day. I thought I had some money in here to use. What do you do now, sir?
Go ahead.
It doesn't really.
All right, but you've been here. Well, you blew it off several years ago, and then I kept renewing the warrant every year, and eventually you came in to take care of this, which is a good thing. So I recalled the warrant for your arrest. Prosecutors recommend fine and costs and time served. And I don't object to that. Apparently, I don't even know if they even have any victim input. This is a no contest plea. 1 day jail credit, 1 day. A $100 fine, $75 crime victims' rights fee, $50 state minimum fee, and a $150 attorney fee. That's $375. Do you want me to give you a date for that, or you want to set up a payment plan?
Yeah, I can pay that today, so.
All right, very good.
Thank you.
All right, that brings this matter to a close after almost 4 years. No warrant hanging over your head, no additional jail time. It will show as an assault and battery on your record, but there's no firearm restriction for that. The bailiff will take you out to the court office. You can pay the fine. And
Thank you, sir.
all right, good luck. How about if you don't come back?
And Your Honor, I'll circle back on the other ones.
All right, do you still have some others pending?
I have 1, 2, 3, 4. I know one is here, but I haven't checked the hall in a moment.
All right, well, we've got all morning.
So Mr. Hendrickson, could you raise your right hand, please?
Yes,
You swear and affirm the information testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And then how is it that the Mattress Depot, it said you're suing 2 different establishments, is that right?
It's one establishment's 2 different locations. Well, there's the purchase location and then the corporate office.
Well, how is it that, let me hear from you, you're asking for a judgment in the amount of $2,984.94. Explain to me how the Mattress Depot folks owe you that.
Okay, Mattress was purchased in October of 2024. It's an item that was purchased at a discounted price of $2,621. It was on the invoice itself, it says it's a discontinued floor model liquidation price, and that there are no returns, no exchanges. And what has happened is, well, this is a higher end bed. It's supposed to be a good bed, right?
And this is just the mattress. I mean, bed to me is something different from mattress.
So in this case, it's mattress.
Okay. So we're just talking about a mattress, not the bed or the frame or anything else.
No, just the mattress.
All right. Continue on.
Okay. And so the bed was used for a period of time, and we started to have some issues with it, some back pain, and feeling like there's something wrong with the mattress, like there's springs in it or something that are a problem. And then we also felt that that it was sagging and difficult to sleep on. So what we did is we took a look at the warranty on the bed, and the bed comes with a 10-year limited warranty from the manufacturer, and that's a tag that's on the bed itself. And if you look in the exhibits, it's there. It's an A-rated bed with a good warranty on it. And so we tried to make a warranty.
I'm going to stop you there for just a second, because what I think I'm going to hear in a minute from the folks from the Mattress Depot, that since this was sold off the floor, it may be a discounted rate. I think you said discounted rate, that the warranty doesn't apply. And so I guess I'm anticipating what I'm going to, and I'm getting that based on what I've read in the file. So I guess I want to hear your response to that, because I think that's kind of be key to how this case is going to be decided, frankly.
Right. So the only part of that apparently is an exclusion, which I discovered later when I tried to make a warranty claim, is the words floor model. When the words floor model are on anywhere, if it's a floor model, then the warranty will be, it's a warranty exclusion. And that was not disclosed on the invoice itself. It didn't say that no warranty. It didn't say the bed is sold as is. It was just a discounted price as far as I was concerned, and I wasn't going to return it to the store. It seemed like a good bed there. So the bed is supposed to be a good bed with a warranty, and they put an exclusion in the language that makes it so I can't get a warranty replacement when making those claims. And I've made the claim with both Mattress Depot. They essentially denied it, said, "Oh, the company will not take care of this warranty." I went to Simmons, the underlying company, tried to make a warranty claim, and they denied it because it was a floor model. And that was they basically won't let me continue the claim because it's already excluded from the up front. Was not aware of this at all. They did not tell me that there's no warranty on this bed. They did not say that. It was not disclosed at all at the time of purchase. I felt that, yes, while I couldn't return it, a warranty was still in place. So if there was a problem with the bed, I would be able to replace it. And so so I feel that the bed at this time, because it's defective, it's worthless. And that's why I feel that they should pay me that money back.
Okay. Who wants to speak for the company, first of all?
I'll start off, and then John can fill in any of the holes if need be.
Okay, Mr. Smith, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. And so then I'll hear from you. What's the Mattress Depot's position?
Sure. Little bit of background. We've been in business 25 years. We actually started out as a liquidator, only selling non-warranty products from all the manufacturers, Simmons, Tempur-Pedic, Sealy. So we're very well adverse in the warranty laws of these manufacturers. Number one, we don't give a warranty to any of our customers on any of our product. The warranties are all held, and most of them are limited warranties. If you read the warranty tag that's on the mattress, it's very clear what they cover and what they don't cover. And in this case, it was no difference. Even with the plaintiff's own filing of what is excluded in a mattress by Simmons is getting down to that on the page there. But, they will exclude for anything, for being a floor model, excessive discounts, if there's any stains on the mattress, if you remove the law label, sorry, just getting down to it. So if the height and then it says things that aren't, covered. Body impressions must be at a certain depth, which this one does not. Even if they didn't exclude it from a floor model perspective, they would have excluded it from it doesn't meet the depression exclusion. They don't cover corner and handles, burns, cuts. I mean, there's this whole list of things. I mean, it's really hard to get a mattress company to cover their warranty. It basically, you have to have a spring poking out because it's just a bunch of springs and foam. And while they'll compress, there's not an engine, there's no electronics. So they're pretty limited in their warranties. They do cover them when I've seen plenty that, are valid warranty claims. That being said, Michael purchased a Simmons Beautyrest Black mattress. It was a floor model. It had been on our floor for a year. We use it, and then when they switch, these are all national brand models. When they switch, we have to liquidate the floor models, and those do not come with a warranty, but we disclose always that's what they are, and then we severely discount them. So in this case, this was a $4,299 mattress. He paid $2,621, and very clearly on the invoice and description, it says discontinued floor model, liquidation price, no exchanges, no return, sale is final. And that was the maximum amount of characters that's allowed to put on our invoice. So just from our software alone, we could not disclose any more information on that line item. He initialed it, he agreed to it. We also just have, from a company perspective, we have an exchange allowance. We allow customers to exchange if they purchase a mattress protector. He literally declined any exchange protection on there and assigned it. So he said no mattress protector, declines exchange protection. That only goes out to 4 months, and this is 8 months later, but still, had he purchased a mattress protector, we would have just exchanged the mattress for him. But he declined that at the time of sale. He was notified at the time of sale, this is a floor model, you're getting this mattress. That's what was delivered to him. He signed the delivery ticket, which is exhibit number 2, showing exactly the same exact information that was on the original sales order. He said he received it satisfactorily, and he slept on it for 8 months. Then he notifies us he has an issue with the mattress. And that's where I'll probably let Jonathan talk, because he's a little more detailed in it. But this was never even about a warranty issue to start out with. So we just received emails of lies and innuendos and this that we're like, look, we want to help you, but come on in and we'll exchange for another mattress. We're past the period we said we wouldn't. No, we're not coming in. We're not paying another dime kind of deal. So we went above and beyond. We were willing to go against our contract even that he signed, initial, dated, everything. I mean, we could not be more clear. And Jonathan tried to work with him after
let me hear from, I'll hear from John. It says John there. Let me hear from him rather than you tell me what he did.
Okay.
Mr. Huffam, could you raise your, is it Huffam or Huffman?
You said that correctly.
Huffam. Raise your right hand, please. You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down.
So I'll pick up the thread here. We got an emailed complaint from Michael very late June. I called him very late June, first week of July, right in there. And about a complaint that they had emailed in. There were 3 points to the complaint. One, they expected a new mattress, and they did not a discontinued floor model. There was verbiage in that complaint that said, hey, the mattress is over a year old. Why is it a year old? This isn't right. 2, the product on their receipt did not match what they had physically received, and they sent in law tag labels to be able to verify and show that. And then number 3, they said the mattress is uncomfortable and they want to do an exchange on it. So I called them and I said, hey, talk to me about what's going on. We're 7.5, 8 months in here. Why are, usually when there's an issue, it's much earlier than that. And so they just laid in right away. The salesperson lied to me. They told me that I was buying a brand new mattress. And then the mattress that we were going to buy doesn't match the one that was on the floor. It was a bait and switch. They went into all of this. And all of these complaints from Michael are documented in the record, because these are all in writing that they sent in to us. So I said, hey, you signed an invoice. You sent me a signed copy of your invoice, because the version that Michael has is a copy of his signed invoice. Said you've initialed next to where it says floor model. Explain to me why you thought you were getting a new mattress when this clearly says floor model. It was clearly, your initials are bracketing the statement there. Help me understand where their confusion in here. And they kind of waved that away as though they weren't paying attention, or they weren't looking at what they were signing. I think, Michael, you might even remember this, where I said, well, are you in the habit of signing things that you're not paying attention to, that you're not reading fully? You don't know what you're signing?
Okay, so yeah, I want all comments directed to me. Don't engage. Well, I'll hear from you, and then I'll give him a
Okay.
chance to respond.
So then the third thing was the mattress is uncomfortable, and I was sympathetic to that. I said, look, I understand that it's uncomfortable. Let's take the first two pieces and set them aside. And I'm sympathetic to the fact that you're uncomfortable. I can't replace the mattress for you. I'm not going to be able to do it any type of a comfort exchange. You declined that on the original sales ticket. We're 8 months in, so even if you hadn't declined it, we'd be 8 months in. You can't get that at this point. But I have considerable leeway, considerable authority granted to me by the owner of the company to try to help out our customers when they purchase a mattress that they then come to say, hey, this isn't comfortable anymore, far past the time. So I invited them to come back into the store and to look at mattresses again and to offer them a discount that would be something only I or another executive or leader at the company could do. They declined that offer. I couldn't specify what that offer would look like because we carry 20 different mattress lines that have different costs associated with them. I don't know what I would be able to offer to them until they come in and say, hey, this one's comfortable. What can you do for me? I'd then be able to try to figure out what I would be able to do. They declined that, saying that they didn't want to spend another red cent in there, and not one more dollar at Mattress Depot, and I respected that decision. But there was no way for me to be able to do any type of a claim. Well, then the verbiage then shifts. They started becoming started doing some mudslinging about the people that were in the store and working there. Again, this is in their second email. Started doing some mudslinging about the people that are in the store. Two people that have been working together for quite some time, very amicably, I might add, and have been with us for a number of years. And we just the complaint ended up evolving into where it is now, where the mattress is bad. We want a new mattress because it's failed. To David's point earlier,
Hang on, Mr. Hupham, I apologize. I'm going to ask you for a stop. Yeah. I apologize, Mr. Hupham. You can continue.
Thank you, sir. So at that point, the claim had or the complaint had evolved into I want a warranty exchange. The mattress has failed, which again I want to take us back a second. Originally, this was you sold me a mattress that was not brand new. It was used, and that's wrong, even though it was fully disclosed. And then it was a claim for a bait and switch. You sold me a mattress that was different from on the floor. That was the last one in the company. They received exactly what they purchased. And then they declined the offer to come back in, in sympathy, trying to do something for them, to help them out a little bit, to get something that's comfortable. And it has gone to the point now where they're claiming it's a warranty issue. The pictures that they sent in, even if it was, it would be allowed for a warranty if they had purchased it at full price from us and did have it was warrantable, it would have still been declined by the manufacturer because it does not exceed the specifications that the manufacturer has stated are required to be eligible for a warranty claim. What this looks like on our end is that they got a mattress that ended up being uncomfortable 8 months in for whatever reason. I'm not even going to speculate on why their needs might have changed in that 8-month period. But they want a different mattress than what they have now, and they're hunting and fishing for an excuse or a reason to make that happen. And we've tried working with them. We tried to work with them in June. We tried to work with them in July, and they have been unwilling to hear anything other than just replace my mattress or give the money back.
And Mr. Hendrickson, am I saying your name, first of all, correctly?
Yes, that's correct.
I'll give you the final word here.
All right. What I want to say is that the mattress was not purchased as a used mattress. I don't believe they're even allowed to sell used mattresses, as far as I know, unless they say that this is a used mattress. It was never sold as is. That language was not on the original agreement. And it was sold not identified as no warranty on this mattress. And there's no warranty. It doesn't say that anywhere on the original invoice. Felt that I was getting a new mattress. It should have not been defective. It sold as new, And even though they put this hidden language on there about the floor model discounted price, it shouldn't be part of an exclusion on a manufacturer warranty, and it shouldn't be excluded from warranty. It's a 10-year warranty. And I believe that there's a claim on the warranty. And at this point, I think the bed is defective and I think it has zero value.
So my ruling on this as follows, there, Mr. Hendrickson, and I just from my own personal experience, and I'm looking at the invoice that was referenced by both the folks from the Mattress Depot, and with your initials, it says discontinued floor model, liquidation price, no exchanges, no returns. And no, it doesn't say a used mattress, but, I look at this as like a demo. Like if you're buying a car, whatever, they have cars on the lot that they demo, people can take out and test drive and so forth. And, sometimes car dealers will sell those and sometimes they won't. But when people buy demos, they generally know what they're getting. It might be at a discounted price. And the reason it's a discounted price is because it's been driven a lot more than a car that has, 1 mile on it on the floor. And that's why that happens. And I look, and sometimes there are some companies who won't sell stuff off on this floor to avoid what's happening here right now. But when it's when you buy something off the floor, you would expect, I would, frankly, I've done that before, where you buy stuff and I expect that I know what I'm getting, in the sense that I'm getting a demo that a lot of people have laid down on, trying to figure out whether they want this mattress or not. And it's apparently been on the floor for a long period of time. And it says right there that, this is a demo. They didn't say demo, it's a discontinued floor model. So that means that tells me that that's again, it's when you walk into a mattress or furniture store, they have all kinds of furniture out there. And but then they'll just have you sit in them or lie down on them. And then if you want that one, then they'll go to the back and order the new one in plastic rack. And then there you go. But the whole reason it was a discounted price, in my view, based on the testimony, is because it was a demo. And the warranty, I mean, that's with the company, with the Simmons there. And again, I saw the warranty that I think it was submitted by both parties. It's, the reason they don't cover floor models or demos, again, that's my word, is because that they don't know what's happened to it it's not a brand new mattress. And so it's a long way of saying, maybe you've heard the term, the buyer needs to beware, let the buyer beware. When you're buying something from off a demo, it's kind of give and a get. You're getting what you think is a good deal on a mattress, but the reason it's exchanged is because the reason it's lowered is because it's been on the floor for a long time. So this is a long way of saying I'm fighting for the defense. I'm not going to enter a judgment in your favor. And if you have a claim against the warranty, that's between the people who provide the warranty, and that's the mattress company. And it's fairly explicit on that warranty that floor models that aren't necessarily brand new. And if it's a floor model, if you're buying with which your initials are right next to it, I mean, I don't think that produces an expectation that you're getting a brand new mattress, frankly. And so I'm going to fine for the defense. I'm not going to enter a judgment, and then the claim will be dismissed. And that'll be here for today. That'll be it for today. You all are free to leave.
Thank you, Your Honor.
Your Honor.
And Ms. McGuire, come on the Zoom call there. And then Ms. Dakoudi could come on the Zoom call. This is a case from last week. And or maybe it was 2 weeks. I guess it was maybe 2 weeks ago. In any case, this was a contract between Ms. Dakoudi and the Heart to Heart Home Care. There had been, again, I won't get into all the facts that came out of trial. We had kind of a lengthy discussion the last time we were here. The long and the short of it is, Ms. Dakoudi was the attorney. Had power of attorney for a patient who was receiving care from Heart to Heart Home Care. That fell apart fairly quickly. There was a deposit given. Ms. Dakoudi wanted the deposit back, and then there was the issue of notice and all that sort of stuff. And so, but what I'm deciding with regard to this case is what I hinted to last time, Ms. Dakoudi, and I did see that you had submitted some things about where you found some money into the account of the patient, and then that went to the heart-to-heart home care. And so, but the long and the short of it is, and I did some looking on this, you know, the real party in interest, the person who needs to be the plaintiff, was the patient. And so this is going to be, I'm going to find at this time, I'm not going to enter judgment. It'll be dismissed without prejudice, but it can be refiled with the real party in interest being the patient. You know, I can't do something that says, well, since you put that money in, I'm going to give this money back to you. It doesn't quite work that way. It has to go back to the account. If I decide in that favor, or whoever judge finds, it has to go back where it came from, and it's the account of that particular woman. And there's ways to do that, but I can't award the judgment in you because I'm finding that you're not the real and party in interest in this case. But then that's what I'm doing with this case.
Could I ask a question? Okay.
Yes.
I do understand that. However, having Pam be the plaintiff when she is not mentally functioning, she cannot come and do anything. And that money can go back into Pam's account. It doesn't have to come to me. It goes into her checking account. And the fact
hang on. Okay, I'm going to stop you for a second. Yeah, all that's true, but she needs to be on the, you know, she needs to be the named plaintiff. You can't, you know, not
I thought we had both names on there. Both her and I were on there.
I didn't see that.
It said Diane Dakoudi and Pam Pays. Because the point being too is that after she had to go to the hospital, they called me that night and said she would not be released, that she had to go to a facility.
On the notice of your claim, into your claim I'm talking about, you only have you on there, not her. So this will be dismissed without prejudice. You need to refile a claim. I'm not going to go much further on this, but she needs to be the plaintiff on the claim, which she is not right now.
Well, you mean simply I have to have her name on there, even though her name
I'm not going to give you legal advice or tell you how to do this. I'm telling you, you brought this claim on your own behalf. And if I were to enter a judgment, the only person I could enter would be to you, because no one else is named on here. And there are ways of doing that, but I can't, it'd be inappropriate for me to sit here and tell you how to do that.
Even though it was my money that went into
But
her
ma'am,
account?
but listed on the contract is her. You did that as a, I mean,
on her behalf,
I
because
don't know
she
how
couldn't
much clearer
sign
I can
anything.
explain this to you. And the person who was receiving the benefit was her. It was her name on the contract, which you signed on her behalf. The money came from her account. And I understand that you gave it to her then. And but I can't do an order when the money was given to the heart-to-heart home care from her account. I can't say, well, I'm just going to give it to you now because, you know, it didn't come from you originally. It came from you. Didn't come to heart-to-heart home care from you. It came from the account with her name on it.
Then why can't they just deposit it back into her account?
They can if they choose to. There's nothing to stop that. I'm saying I can't enter a judgment in that way because she's not here.
So I have to, if they choose not to give that deposit back, which she
Clearly
deserves.
they haven't. And I don't know whether you can reach some sort of agreement with them or not, but apparently not, which is why we're here. But I'm saying the way this lawsuit comes to me now, I can't enter a judgment the way it's drawn up. And I've tried to explain it to you, yeah.
So if hopefully they will give the money back, which is deservable since the notice was given.
Yeah, you can speak with them about
And
it.
if not, then I have to go through all this again.
Probably, yep.
All right, well then hopefully Heart to Heart will return the money
This
since
will
they
be
were
this will be
given.
dismissed without prejudice.
So what do we do now?
Ma'am, I can't tell you what to do. I cannot advise you.
Sherelle, can you say anything? Will you return the money?
Okay, so ma'am, I'm not going to have you do this on the record here, where it's something you can talk with them about it, and then you can examine what your options are on behalf of the patient. And again, we're not going to do this now on the on the record, where the case will be dismissed, and then you folks are free to, I mean, you did attempt to do some resolution before, but and apparently no agreement was reached, but we're not gonna, again, you can have conversations with them or not. They can choose to talk to you or not, but we're not gonna do this here on the record in open court. This will be concluded as of today.
Okay,
That's it for today. You're all free to go.
Thank you.
thank you.